Today is Sunday, June 29th, 2025, and I want to ask you, what have you done to prepare for the best possible outcome if you're facing criminal charges? One thing you could be doing is learning more about what's coming. And I got a question for today from somebody who's participated in our masterclass series. He's a physician and he's facing some challenges with the criminal justice system and anticipates that he may be going into the criminal justice system. And so we started speaking about, well, do you understand what's coming? All of this information is available for free right on our website at prisonprofessors.org. You can see it right there. I would really encourage you to visit the site if you're facing these kinds of challenges, because nobody should be working harder than you to prepare for the best possible outcome. I am Michael Santos, and I was incarcerated for 26 years. You can't do 26 years in prison and not feel this sense of despondency for people who are going in, because I know what's in there. But I also know that there's always more opportunities in the future than in the past, but only for those who prepare. And one way that you could prepare is by understanding the sentencing process, what to expect. The guy I spoke with today, he participated in a masterclass with us that I'm going to be publishing tomorrow on our website. But we didn't talk about the challenges he's facing with the criminal justice system. We really just spoke about all of the lessons that somebody can learn from an individual who not only worked really hard to get into school, to get into medical school, to get a scholarship in undergrad school, a scholarship in med school, join the military, serve the country, become an emergency room physician, and then become an entrepreneur, launching an entire new industry, which is really exciting for me to speak with him. But this is an area that he was an expert. The area where I'm an expert is understanding what steps should somebody take to put themselves in a position for a better outcome. I only know that because I was arrested when I was 20. I started breaking the law when I was 20. I was arrested when I was 23. I was sentenced to 45 years in prison. And I served time in prisons of every security level during the time that I served. But one lesson I learned is that you should, if you want to get out early, that you've got to start preparing early. And that's what we strive to help people understand at prisonprofessors.org. So when the guy didn't understand, well, what's going to happen at the sentencing hearing, I thought, well, why don't I just make a video that I could explain it for you and explain it for anybody else who's a member of our community. So when a person is convicted, okay, that conviction begins the day that a person pleads guilty or the day that a jury returns a guilty verdict. I was convicted at trial. A jury returned a guilty verdict, and at that moment, I was convicted. Most people plead guilty, and the day they plead guilty, they are a convicted felon. They may not be sentenced yet, but they're a convicted felon. Either way, when there's a conviction, there's a process that unfolds. And the first process is the pre-sentence investigation. So you really are going to want to learn as much as you can about the pre-sentence investigation before that date. Now, your lawyer should be helping you, but a lot of times your lawyer is going to focus, as he should, on the judicial process. But the pre-sentence investigation is an opportunity for you to start sowing a mitigation strategy that will influence your life while you're in prison, potentially getting out of prison, and potentially the level of liberty that you have on, when you're on supervised release. And maybe even qualify you, if you play your cards right, for early termination of supervised release or clemency and a commutation of some kind, right? So you got to be thinking about, what does every part of the process, how does that influence you going forward? I didn't understand that. If I understood more about the Bureau of Prisons, sentencing, and all the collateral consequences that follow a criminal conviction, I would have made different decisions. I made really bad decisions, and for that reason, I served far longer in prison than I should have. But I don't want that to be your situation. If you are facing a challenge, learn about the pre-sentence investigation. What's going to happen is you're going to meet with a probation officer, hopefully in the presence of your attorney. They're going to ask you some questions, and you are going to have an opportunity to influence what goes into that report. And I would really encourage you, learn everything you can on how to influence that report. because it will follow you after the sentencing hearing. So once that report is, the probation officer listens to you, the probation officer will also take all of the information they have from the U.S. attorney, the prosecutor, the FBI agents or DE agents or whoever investigated the case. They will probably speak with your family members, your employer, anybody that knows you. Because what they're, in theory, trying to do is put together a report so when the judge considers what is sentencing, he's got more background than just the crime and the conviction. And it's you have an opportunity to kind of influence that report. And I would really encourage you, learn how to do that well, because it could have a huge influence in your ability to qualify for administrative relief later. Now, the next step in the process is the sentencing hearing. And my recommendation to you is you learn everything you can about the sentencing hearing. Got a lot of free information on the website, but you're going to have to take the time to read that information, watch the videos, think about how these lessons that we're offering can apply to you, and what can you do to influence that journey ahead. Because at the sentencing hearing, I'll just tell you what's going to happen. The first thing that's going to happen is the judge is going to go over that pre-sentence investigation report, because it most likely your prosecutor is going to have some objections to what the probation officer wrote. Your defense attorney is going to have some objections to what the defense attorney wrote. And before the sentencing hearing, the two attorneys are supposed to kind of work together and come to terms with that report. But a lot of times they don't. And so the first thing the judge is going to do is make what's called a finding of fact. That's the first thing that'll happen in the sentencing hearing. The judge is going to ask the prosecutor, where's the discrepancy? The prosecutor is going to give his version of events or her version of events. The defense attorney will then stand and give their version of events. The judge will take this into consideration, make a decision, and that is what becomes now a fact. And that fact is going to influence the federal sentencing guidelines, which I would really encourage you to learn about before you go to sentencing. So that process may take an hour. It may take half an hour. It may take 2 days, because there can be very complicated matters in that pre-sentence investigation report, including amount of loss, if it's a drug case, amount of drugs, culpability, enhancements, and there could be a lot of back and forth, and the judge may want to really meditate on that and make the right decision. But it's going to influence the sentencing guidelines. So once the judge makes a decision, it's no longer a point of contest. It is a fact. So if you understand that, you might take some precautions early and figure out, well, what battles do I want to fight here? Because you're really about to make the biggest sale in your life, and you should leave the lawyering to the lawyer. You should be thinking about what kind of mitigation strategy can you put in place. And that would include, of course, putting together a batch of character reference letters, hopefully developing a very comprehensive mitigation strategy that advances you as a candidate for relief. You see, the judge is already going to know what the prosecutor has to say. I mean, after all, he is probably a former prosecutor himself, and he understands that the prosecutor is going to ask for a very severe sanction because that's his job. That's the judicial process. He represents the United States of America, and that job is to ask for a penalty. So understand that. Then you're going to have the other side, which is your defense attorney. And the judge very likely knows what the defense attorney is going to do, because he was probably once a defense attorney. And that means the defense attorney is going to argue why you deserve a lower sentence. So the judge knows all of that. The probation officer is going to have his opinion. The judge knows that. The one thing the judge doesn't know is you. So it's super important in this for you to prepare all of this before the sentencing hearing. After the judge considers these discrepancies in the PSR, by then he will already have reviewed any character reference letters that have come in. He's going to have reviewed your mitigation strategy. Then he's going to ask you if you want to address the court. My recommendation always, of course, is to use your discretion, deal with your attorney, but nobody's going to be more important in that hearing than you. And so I would really encourage you, review all of the things on our website, make sure you get a good understanding of what a good allocution sounds like, because a lot of people really drop the ball there. And those aren't my words. You could look at judges I've interviewed and published them on the website, and the judges have spoken about the ways that a person can really talk himself into a longer sentence. Because too many people go to that sentencing hearing and they think it's another opportunity to litigate the case. Wrong. If there's a sentencing hearing, there's been an adjudication of guilt, whether you pleaded guilty or whether a jury found you guilty, and now you have to start dealing with the reality of that sentencing hearing. And I'm not going to tell you what to do. I've written extensively about it, but every individual needs to make his or her own life. That's what you could expect at the sentencing hearing. After the judge makes a decision, the judge will say, I hereby sentence you to the custody of the Attorney General. And at that point, you are going to move jurisdictions from one branch of government, the judicial branch, to the executive branch, because you're in the custody of the Attorney General. And the Attorney General has the discretion of where you serve that sentence, including home confinement. So it's up to you to really develop a mitigation strategy that will advance you as a candidate for home confinement at the soonest possible time. And you know when that starts? Today. It's kind of like that old analogy. The best time to plant an oak tree, it was 20 years ago. But the second best time is today. I know that if you're consuming Prison Professor's content, you wish that you were not. Okay? Nobody wants to be going into the prison system. But we have to live in the world as it exists. And if you're going into the system, it's super important for you to understand what's coming. That's why I encourage you to understand the sentencing process and everything that's going to happen, and then figure out strategies you could use to put yourself in position for the highest level of liberty at the soonest possible time. And I offer all that information through our nonprofit, where I always make 3 promises. 1, I'm never going to lie to you. 2, I'm never going to ask you to do anything I didn't do. And 3, I'm never going to charge you a penny. Visit us at prisonprofessors.org to get free information. This is part of a ministry for me to try and reduce America's prison system and help more people get out with their dignity intact and with opportunities to prosper. You be cool. I'm Michael Santos, and I believe in you.